Hello, and today what I want to talk to you about is the equitable remedy of specific performance. Now, this is the remedy whereby you oblige the defendant to specifically perform an action. So it arises in contract law where you have two parties that made terms, contractual terms to each other. One party has breached the contractual term, and so in the judgment, as a remedy, the judges will say, oh, well, now you have to specifically perform that term you have breached for so and so reason. Now, it's an equitable and discretionary remedy. So I have a lot of posts explaining things about the law of equity, etc. But in essence, what it's saying is, in English law, when you have a contract, if a term is breached, you have damages. Because what the philosophy is, the idea, the underlying concept is that if you make a breach, then the other party has some kind of financial loss or some kind of loss that can be quantified. So if you pay them in damages that loss, then they are made no worse off than if you had not breached the contract, and therefore you can move on with your life, and that's kind of the end of it. Whereas in the States, it's very different. You have punitive damages. You would ask the damages to be beyond the loss that's made because you really want to punish the party and tell them not to breach contractual terms. But it's very different in English law. However, this is not always enough, and sometimes you actually need that covenant to be, that term to be specifically performed. So this arose in the case of Beswick and Beswick. Now, this case was actually a lot to do with the privity of contracts, so because the idea was who can enforce the contract. But in terms of specific performance, where it arises is, in essence, an uncle, he gave his business to his nephew on a contractual term, saying that you will pay my wife after I die a certain sum every year or something. And when he died, so the nephew inherited the business, and I think he made a one-off payment once or twice, but after that he did not, so he breached the covenant, which, you know, this is what he signed up to. This was the contractual term. So, what happened was, there was issues regarding privity of contract, but that's not really important here. The key thing is the wife was also the administrator of the will. So from that, she was basically like the legal entity holding the contract with the son, and so she could ask for that term to be specifically performed, and this is exactly what happened. So when it got to the House of Lords, they said no. What is the just and equitable thing to do? Damages is not going to help the situation. It's, you know, what is it going to do? Because the whole point of this term was so that she would be made financially secure for the rest of her life. So, and it's just the just and reasonable thing to do, you know, the standard vague language that judges use. It was the right thing to do, basically, to the facts, and this is what they did, and that is specific performance. Now, it's interesting to look when you look at leases. Now, leases are really interesting because they're contracts between two parties, but they're also, the lease gives rise to a proprietary right. So you have a contractual right between the landlord and the tenant, so you can use the terms against each other. But it's also a proprietary right because as a tenant, as somebody who's leasing a property, you have the right to exclusive possession. So much so, you can even chuck out the landlord. So, i.e., your rights are against third party, not just one specific party, making that proprietary right, not just contractual right. So it's really interesting. So what happens here is, regardless of whether you're looking at whether it's a repair covenant or a non-repair covenant, you can potentially have specific performance as a remedy if a covenant has been breached. However, it's important to note this is quite limited, as I'll explain. So in essence, what it is for a long time, only tenants were allowed to force through legal action a landlord to act in a particular way. But then what happened is, you have this case, Rainbow Estates and Token Hold 1998. And in this case, they actually obliged a tenant, so they used specific performance as a remedy for a breach committed by a tenant. It was a repair covenant that had been breached. And so what they said was, in this situation, the just and the equitable thing to do would not be damages. And this is because of two reasons. The first is, it was clear that the disrepair of the property was caused by the tenant's action, and the seriousness of disrepair was very serious. It was actually a public policy issue, if you look at it, because I think there was also things about the Environmental Protection Act of 1990, there was notices under that, the local authorities were involved, it was a public issue, so it was pretty serious, the disrepair. And then the judges considered, well, what do we do now? And so they looked at, well, the landlord, could he forfeit the lease? No, he cannot, because that clause or that ability to do so was excluded in the lease. There was no clause, alternatively, giving the landlord the right to make the repairs, and the landlord can't just walk into the property and start making the repairs, it'd be trespass. So basically there was a lack of other solutions. Damages, well, the tenant giving the landlord money doesn't do much because the whole issue is the property needs to be repaired and there was still time left on the lease. So what they did is they actually forced the tenant, he had specific performance was used to force him to make repairs. So it's quite an interesting case, and you can see here again, it's just to do it was the right thing to do, as with the Beswick case. But it's very limited in its use, and usually specific performance will not be used in terms of leases, because I mean it's one of those things that, I don't know, like damages fulfills the job, and that's always the go-to presumption. You are looking at damages and you move on. It's only where damages is not enough. And here, as I said, damages would not be enough because the repairs had to be made, and that fundamental thing could only be made through specific performance. And a clear demonstration of this is in the case of Cooperative and Argyle stores 1998. So what happened is the tenants here were an anchor tenant in a shopping mall, and they had a covenant which basically said that they had to keep the shop open and running, and they had to always be there. I think the specific words were keep open the demised property for retail trade. But they were having losses, they closed down, they went, so it was a breach of the covenant, and the landlord said, I'm going to ask you to specifically perform this. Now, in the lower courts, they actually agreed, and they said to the tenants, yeah, you've got to keep the business open, you've got to be there, you're breaking a term of the contract. And they said this because they were having issues understanding what was the exact losses that had caused them to shut down in the first place. That's my understanding of it. And the second thing is that they thought the tenant acted with unmitigated commercial cynicism. So basically the idea that they were overreacting to the market conditions, and it was just not a reasonable thing to do, and it didn't make sense to them. And so they said, no, you're just doing this and it's causing so much loss to the landlord, come back. Now, of course, this went to the House of Lords because it is a bit bizarre, because if you can specifically ask a tenant to keep open their business, then what other things can you do? Specifically ask them to live there if you're looking in a residential context. I mean, it was a bit bizarre. And the House of Lords reversed the decision. They said actually no, because basically damages could be given to the landlord for the losses he incurred from the tenant shutting down, and then he can move on with his life. So the go-to remedy of damages was sufficient. And then Lord Hoffman, he put it so poetically. What he said is, the purpose of the law of contract is not to punish the wrongdoing, which, as I said at the beginning of this video, that's the American system. That is not the point in English law. You do not want to punish the party. We accept two people come into contracts, sometimes things break. It's the end of it. So he said it was not to punish the wrongdoing, but to satisfy the expectations of the party entitled to the performance. So when you're taking on a tenant, you look at things like their DNB credit rating, etc. So you have a particular expectation of will they be able to fulfill the contractual terms that are being drafted, and you have to accept that yes, if market conditions, the recession came, then even some of these small to larger businesses, they go bust. You have to accept that it's part of the game. So he was like, it was foreseeable actually, that's the kind of point. And there was financial loss, yes, but there was damages, so that's fine. And there was no personal breach of faith, so there wasn't this idea that you've been misled or misunderstood into the contract. It was just what it is. And so from there you can see that basically the idea is that you don't really use specific performance. You use damages. That's a go-to for any kind of contract, including leases. But where the situation dictates, specific performance will be used. So it can be used like in Beswick, where damages are not sufficient, and the same way in Rainbow Estates, damages would do nothing. The repairs had to be made. Anyway, thank you for watching.